defense attorney, and they're swapping deals. And, you know, they're going to come up with some, okay, how about 10, 15, you know, and like, I don't know, I don't even know anything about the criminal side. But like the notion that these tools would be relevant to that makes me understand that you're right, the judicial system is largely about architecting settlements. That's the way this stuff happens, and agreement between.
Maybe it shouldn't be that way. Maybe you know, these technologies are not going to provide adequate impetus to reform the system, but that's what it is. I mean,
or maybe they'll free up some time.
Or maybe they'll free up some time.
So for certain
for the really hard cases, because
right.
it's the hard cases and the cases that have a lot of money behind and people that can pay for it that actually do.
I've got a friend who's a law professor at the University of Kentucky, and he wrote a book. Essentially, they made that argument. They said, you know, let's use all of this technology on the civil side. Let's increase efficiency. Let's save money. Let's take all of that money we're spending on civil caseloads, use technology to save it, and then put it all into the criminal side. Because that is life and death, and we are underinvesting. You know, the amount of money that we give to public defenders, the amount of money that we are not living up to our obligations on the criminal side. So he's saying, don't take $1 out of the court system, but reallocate it by leveraging these efficiencies. So it's kind of along the line of what you're saying.
And they actually, I think that in Kentucky what they have is they have a system that which is quite efficient, much more efficient than judges deciding on bail hearings. Mm-hmm. So you have, what they did is a study where this was done for the state of Kentucky by a private firm, but what they did is looked for a long time at judges' decisions, and they found that judges were looking at 21 parameters, out of which only 3 actually affected their decision. So the algorithm then they were able to use this in order to shorten very much the interviews that they had before bail hearings and to make the system much more efficient. But so, I mean, it is done in some places, but you know, this is so interesting, and a lot of, I mean, I still have to think more about this, but I must say that one thing that really bothers me is the control of the algorithm. Mm-hmm. Once again, I'm going to this point because you said human review. However, once we use big data and we have personalized decisions, the more we know and the more parameters we put into the system, we lose the benchmarks. I mean, so it might be that somebody else got a different outcome than I did, but just because I have different parameters that come into play, which the algorithm can calculate, but the judge couldn't because it was too complicated for him or whatever. Mm-hmm. So I'm just wondering if we're not losing the ability, you know, this is the benefit on the one side. It can be personalized justice, but on the other side, it might be that we're losing our benchmarks, we're losing our ability to really know if this is good or if this is bad.
Yeah, I mean, one of the interesting things as a dispute resolution person, alternative dispute resolution is alternative because it's alternative to the courts. I never wanted to be inside the courts. It was very odd for me when I was acquired by a court technology company and suddenly we're building OER into court processes because I never wanted to do that. I wanted to buy bulletin boards outside the court's house and put up, don't go in there.
Yeah.
You know, come to me, I will take care of you. Because again, we're trying to create an alternative. But for me, I'm interested in disputes that are pre-court, where the parties own it themselves. And then there's no role for the state in a civil case when I'm arguing with someone, a service provider or a colleague. That's a point at which we can work it out. And yes, I mean, it gets to the question of dispute systems design. Does that feed into the FIS argument because we're not evolving the law, this beautiful, you know, human creation that supposedly delivers justice? Well, from my perspective, the vast majority of cases are already resolved in that interpersonal negotiation.
Well, that was one of the interesting contributions you had at PayPal, at eBay and PayPal, because you actually, I don't know if you thought of it that way, but you raised the question of when does a dispute begin? And you didn't wait for them to voice it, and you actually recognized moments before the dispute sort of surfaced.
Well, one of the things we say in dispute resolution is the best way to resolve a dispute is to prevent a dispute. And because we had the full view of all of the disputes, 60 million a year, we eventually had hundreds of millions of cases in our database, we could figure out what's causing these disputes. And then we could go upstream, and then we could prevent those disputes from arising. And I can tell you lots of stories about how we did that, but the courts don't do that. very rarely, I mean, we think of it as a purely reactive process. A case comes in and we have to deliver a just process to figure out the outcome. But if we see recurring issues that emerge in response to certain irritants, why wouldn't we go upstream and then remove those irritants to prevent those cases? Or if there's misunderstandings, I mean, that's what a lot of lawyers do. You know, you write contracts and say, look, these are the 10 kinds of issues that may emerge in this business relationship, so let's address them in the contract so that we don't have those misunderstandings downstream. But if we have truly holistic vision of the system, we should be able to make these learning systems and see the cases that are coming in and seeing what resolutions are achieved and be able to go earlier in the ecosystem and prevent those disputes from arising in the first place. And that's not what's happening now. You know, the courts are not going out and fixing the homelessness crisis in California because they're just drinking from the fire hose as the problem gets bigger and bigger and bigger. So we need to go back and fix the source that's creating all those problems, and we can learn how to do that from the decisions being rendered by the courts. But right now it's too segmented. So that's, again, from an online dispute resolution perspective, hopefully we can take a more holistic. The other thing I think is very interesting is courts often render a decision and they're like, okay, good luck. You know, and what we find is it's in the further monitoring of the health of that resolution to ensure that the issue doesn't arise again. So we do that in some of our ODR systems. It's not over when a resolution is achieved. You have to monitor that resolution and then evolve the resolution over time. We see a lot of separation agreements. They work great at the point where they're delivered, but 2 or 3 years later, the kids are older, tuition changes, you have to make adjustments, and the courts are not set up well for that. So another issue arises, and then it creates another issue in the courts. Whereas if you had a process that was a learning system that supported those parties, they can make those adjustments as they go along. So hopefully this more holistic perspective, technology will empower us to do that. So.
Yeah.
All right,
So
have we exhausted the topic? Yes. Thank you so much
Thank
for
you.
holding it. Well, it's interesting too because this is how I normally present them. So it's a little intimidating for investors to go where I say, yeah, we How do they differ?